to get started?
We got a room that was kind of like this.
Okay. Okay. Good morning. This is the first panel of the 2 days. My name is Jennifer Leitch, and I'm going to moderate this panel. We have 4 discussions today that are based around essentially sort of listening to justice system users, which is picking up on one of the themes certainly that came out in the first plenary. I'm going to jump right in because we are running late already. And our first speaker this morning will be Meg Holden, directly to my right here. She is a self-represented litigant in her own family matter in British Columbia. And so she has a very personalized understanding of what it means to be in the justice system without representation. She is also a social and policy scientist and professor and director of the School of Resources and Environmental Management at Simon Fraser. And her research examines urban social infrastructure and sustainability. And she is also a member of the National Self-Represented Litigants Project's Board of Directors. So I've got to know Meg over the last 4 years quite well. So when you're ready.
Thanks, Jennifer. Thanks for the kind introduction. The slide that is showing is not my slide, so I think we need to do a little bit of rejigging.
That's why.
So should
Meg should be first, Meg Holden. It was in the right order, I just double checked.
I believe you. That is my, yeah, so that's just at the bottom. Could you scroll up to the top, please? Great, thank you very much. Okay, thank you. Thanks, Jennifer. Thanks to my co-panelists. So to begin, I want to say that it's quite a good fortune for me and an honor to be able to speak in this forum. Generally, I consider myself to be a bad actor and most of you to be good actors in the system of administration of justice. At least I'm going to sort of expose some of the reasons why I feel that way. This is kind of, well, is kind of the only body in which I have felt that the system wants to hear from me as a justice system user. It has seemed that the amount of time that I've spent caught up in the justice system without resolution has persuaded most of the good actors that surely the only thing that I could want is to burn the system down, and that's not what I want. So I'd just like to tell you a little bit about myself. Can I advance this? Yeah, I can. To address the elephant in the room, which is that I have had lawyers and I have made good faith attempts to work with lawyers. You can see a sort of the rap sheet of my efforts to engage lawyers in the resolution of what's a pretty straightforward family dispute measure and an amicable separation in 2014. And really what I want to get to is not the ins and outs of all of my dealings with lawyers, but just to make the point that it's not only about the cost of lawyers, although that's obviously part of it. I'm standing here as a relatively privileged person. But it's also about the adversarial nature of the system and the intricacies of the system, which have left me in a place where there is no viable lawyer representation that's available to me to resolve my dispute. And so the conclusion that I hope to lead everybody to through these remarks is that this is not about me. This is about the things that we care about, and very consistent with the points of the last session. The opening session, I have feedback, and I think that we all do, and the system needs reform. I'm also a researcher, as Jennifer mentioned, so that's kind of my baseline approach to problem solving, and that's why, although I'm trained as a pragmatic philosopher and a social theorist and an urbanist, I find myself here starting research into family justice, whereas I think most people in my situation would have walked away at this point, or at least expressed just sort of puzzlement. So here is my rap sheet. It's the CV that no one would ever see about me because I would never share it except in this forum. There's nothing particularly exceptional, again, about the story of my encounter with family law in Canada. And there's nothing, I would say, deficient or adversarial about the way I've approached it. In fact, I've tried sort of every collaborative trick in the books in order to resolve my matter. And yet I find myself in this shadow of a CV that carries a heavy, heavy load of shame. Being a self-represented litigant is sort of like being in a club where no one would admit that they're a member. So the sort of my interactions in the court system have included 3 occasions being represented by counsel, and then a whole host of occasions where I have wrestled with the system myself. And you can see there, if you look at that slide, that it is ongoing. So last year, Jennifer invited me to a session that was led by the CIAJ, and the judge, Justice Lowers, gave a webinar about how judges can respond to self-represented litigants. And he presented a clever characterization of 4 kinds of self-represented litigants. I'm not going to go through his characterization. You can still find it on the CIAJ website. And the point, he was being generous in this characterization because the implication was that to most judges, most of his colleagues, there would be only one kind of self-reps, and that's a pain in the neck kind of self-reps. So Two can play at that game, and so I'm here to tell you there are 4 kinds of judges in terms of the way they present the justice system to self-reps like me. Those who believe that self-reps should be ashamed of themselves, those who believe that self-reps are stupid, those who believe self-reps don't fit the behavior expectations of the justice system, and those who believe self-reps don't fit the communication expectations. And before I go further, to give a few words about those 4 items, I'll admit that I lied. As far as I've been able to discern, every judge behaves with all 4 of these preconceptions in mind. And these expectations add up to deny the access to justice, to deny the justice system the benefit of the social reproduction bargain that self-represented litigants actually offer to the system. So first of all, shame. Much of the way that I've been treated over the past decade and more within the legal administration system has been intended to sort of make me believe that I should be so ashamed of my behavior and the situation in which I find myself that I should just not want to tell anybody about it. I shouldn't speak of it. And judges will go to great lengths to shame self-represented litigants who appear in their courtrooms. In my view, they often, and this is in the BC case, they will even contract that responsibility out to private sector actors like parenting coordinators, whose job it then is, whose legislated job is to impose that shame, even in absolutely absurd situations such as shame for having given one's children a high five when passing them on a city sidewalk. The second one is that self-reps are unintelligent or stupid. And so this is activating what was recently referred to in the Walrus magazine as the practical oblivion dependency of the legal system, that the legal system continues to function to the extent that it does because it is simply too burdensome to actually get to the bottom of anything. So this shows up for me as the relentless pursuit of procedural and administrative details on which to deny me the opportunity to address the substantive attention that I'm seeking and that justice demands. So through, for example, the rules of document preparation, binder preparation, rules of timing, of evidence, and when all else fails, assuming that there just must exist some hidden stupidity in the self-represented litigant that gives them good reason to call it a day and ask for an adjournment. The behavioral deficiency. So self-reps are assumed not to have earned the right to behave in the antagonistic way that lawyers behave. And so the same behavior that I see in a lawyer acting against me in court is not afforded to me because the system is designed to sort of elevate that kind of adversarial behavior amongst judges, but to deny them to self-reps in the courtroom. And I think this goes back to the first hope, which is that enough shame will sort of build up so that the self-reps will simply go away ashamed of ourselves and stop talking. And this is especially baffling because as a self-rep, of course, I'm on one hand interacting with the court system, and then on the other hand, interacting with the social services sector in government. And within the social services sector, there's an immense amount of deference that's afforded to anything that happens in court. And it's treated as having this sort of level of impossible objectivity that simply cannot be questioned. Without really necessarily any engagement of these social service sectors in the courtroom to have any understanding of what they're doing. So here's the BCFMA is the Family Maintenance Agency in British Columbia, and sort of telling me that it's simple to return to court just to fulfill their needs for different wording, for example. And then finally, communication. So one point I think that will bring this home is that no judge that I have ever appeared before has ever introduced themselves to me. Although it certainly always behooves me to know how to address the judge by name, both because it will annoy them greatly if I do mispronounce their name, and also that they do not, they will call for an adjournment or offer the opportunity to set down a hearing again before them. But if you don't know their name, it can be very challenging to find out who they are. Generally, legal communication is there's this sort of impossible expectation that it's clear, that it's above human mistake, and that any suggestion that it's not clear or different interpretation is a signal of the deficiency of the non-lawyer and not the system itself, or the people who are making human errors within the system. Even when the degree of miscommunication is pervasive and elementary, such as the fact that it has sometimes been impossible to settle whom is the claimant and whom is the respondent in my matter that has been going on for a dozen years. So this adds up to this sort of level of cognitive dissonance of the gap between the expectations of me trying to represent myself and settle something in a child-centric way in the court system, and the way in which the court perceives me and seeks to resolve my matter. Which leads me to the sort of practical implications, which is the kind of feedback that's needed. So we heard the Attorney General for Ontario speak this morning about the 3 pillars of a functioning democratic justice system. And the part that I would like to add is the loop back. And so I think that a serious system of feedback is needed for all those that are engaged with a people-centered justice system in Canada. And these are the 4 questions that I think are important for a system to understand about the users. Are they being humiliated? Do they feel more shame? And why should we feel shame for seeking justice in a dispute resolution that we are compelled to participate in? Were you able to understand what was occurring and what your options were during this dispute? What specific behaviors of the individuals you engaged with in the reduction of this dispute are concerning to you? Because there will be concerns. And what specific communications presented the most challenges to the resolution of this dispute? And just one final slide, Jennifer. So back to this notion of the social reproduction bargain. I would put it to you for consideration that self-reps invest our time and our personal resources in navigating the justice system. We do reduce that cost burden, in a sense, to the state. And we do this although it costs us dearly, and we typically understand that we have no realistic hope of winning. It's just some simple way to sort of continue in our lives in some respect after a significant change. We can't insure ourselves against the risks that come with self-represented litigation. And we do this although the system is arcane, obtuse, and designed to discourage us from participating. So therefore, we offer this sort of way to provide a different kind of feedback into the system with this beginner's mind and with a sense of social responsibility. And without self-reps to perform these essential social reproduction duties, I would say that the Canadian justice system is untenable in the future. Thanks.
Thank you. Thanks. That was great. Okay, next we have Barbara Captijn, who is a graduate of Queen's and McGill. Also had experience as a self-represented litigant, and from that experience became interested in the challenges facing new home buyers in Ontario who try to get construction defects fixed, which is a whole enterprise unto itself, or recover their deposit money through a variety of government agencies and tribunals. So for the last 12 years, she has undertaken unpaid advocacy work on consumer protection issues, supported many self-reps going to court, and advocated at various levels of government for improvement in consumer protection law and better access to justice for new home buyers. She's written numerous articles and active on social media as an advocate for consumers. Okay.
Thank you, Jennifer, and thank you for the opportunity to speak today to this very important group. My talk today, as Jennifer mentioned, is what is it like inside the courtroom for a self-represented litigant? So this will be your eyes on the inside from the perspective of the self-represented litigant. I've done this for 15 years. I don't work for anyone. I'm not paid by anyone. I accompany self-represented litigants to court as a friend and a support person based on the unfortunate experiences I had about 15 or 16 years ago as a self-represented litigant myself in Ontario. I hope that this contribution today can answer the question that the first panel posed, and that is, how do you move from these experiences to action? How can I give you some actionable areas where this group, called the Action Committee for Access to Justice, how can I tell you from my eyes on the inside what I would suggest that you do? I have 3 ideas to propose to you at the end, but I just would like to walk through with you. You know, they say don't criticize someone until you've walked a mile in their shoes. So I would like to walk with you for the next few minutes in the shoes of the self-represented litigant in court. You know, a very famous soccer coach called Johan Cruyff once said, he was criticized for putting inexperienced players on the field, on the soccer field. They said, why would you do that? And he said, that's how I make good players. I put them in the middle of the action and I train them that way. The courtroom doesn't work that way. You can't put a self-represented litigant in court and make a lawyer out of them in a number of hours or a number of weeks or a number of months. These skills take months, years, sometimes lifetimes to perfect. And I don't know why in Ontario we are still pitting self-represented litigants in court against experienced lawyers. This is sending sheep to the slaughter, in my opinion. I don't think we should be doing this. And 15 years of observing how this happens and what happens and the emotional and financial effects that this has on consumers is devastating. Let lawyers fight lawyers. I'm all for that. Bring in the heavyweights against the heavyweights. Let's do it. But do not pit a self-represented litigant against experienced lawyers in court. The system wasn't made for that. And I'm concerned that Ontario seems to be increasing the number of self-represented litigants in court, not decreasing. Many of my lawyer friends joke to me, Barbara, you've spent more time inside the courtroom than most lawyers, because there's a lot of need for people to find that they have a friend or a support person in court, because you feel like it's you against the world. You're playing in a game, you don't know the rules, you didn't write them, everybody's speaking a different language. You really feel it's you against the world. And I'm talking about the consumers who are very well prepared, who've spent weeks researching their case and doing their homework and taking their vacation off work to attend court. In the cases I'm most familiar with are home construction defects. Housing is one of the most personal and important financial decisions that you can make in your life. And also issues like cancellation of housing projects and missing deposits, things like that. Those are the issues that I accompany consumers about to court. And most of my experience is at the License Appeal Tribunal in Ontario, where consumers can appeal a decision made by one of the Ontario agencies, this one called Tarion, which is supposed to be a consumer protection agency, is supposed to administer the Ontario New Home Warranty. But usually that's two lawyers pitted against one self-represented litigant. The lawyer for Tarion, who has in-house lawyers, and then the lawyer usually for the builder as well. And then you've got the self-represented litigant on the other side. What's even the chance? You don't have to be a betting person to say, well, who do you think is going to win that? It should be no surprise to anybody here that 83% of the consumers who go to the License Appeal Tribunal to dispute trying to get construction defects fixed in their new homes lose to the administrator of the warranty. Why are we allowing that? This is an access to justice gathering. I'm appealing to you today. I'm going to give 3 reasons, and I'm coming to that, 3 suggestions of how I think we can address that. But you might say, well, why don't these people who can afford a home, why don't they just hire a lawyer? I'll tell you why. It's cost. Some consumers have been asked for $20,000 deposit to $80,000 retainer upfront to even get an experienced lawyer to look at their case. Hourly fees in the Toronto area are anywhere from $450 per hour to $1,000 per hour. And it could take years to get to court. This is not the kind of expenditure many individual consumers can afford to spend in order to assert their rights. Corporations, on the other hand, have in-house counsel, and they can afford to hire outside counsel as well. And for them, it's a tax-deductible expense. For the consumer, it comes right off the kitchen table. I have a slide, too. I'll get to that slide in a moment. But the slide that I wanted, I think, is it's slide number 2. It's just before that.
You should be able to just.
Oh, we'll just go back a couple. I don't need the slides, but
Which way? Am I going the right way?
go back again, yeah. I'm just going to enumerate here. Thank you, we don't need that's okay.
Is this?
It is up there, a list of all of the hurdles which self-represented litigants have in court. It's probably the second slide in the whole deck.
Okay. I'm going.
There it is.
Oh, there we go.
That's the first, yeah, thank you so much.
I can do them for you if you
Oh,
want.
wonderful, thank you. Why don't consumers hire lawyers? Cost, cost, and cost. Second of all, it's very difficult to find a lawyer who will take on an individual consumer as a client because they believe sometimes that the consumer will run out of money. They may get paid the initial retainer up front, but $20,000 is used up in a heartbeat. And a lot of these cases become more complex as time goes on, and lawyers are afraid that the individual consumer is going to run out of money, which often happens. And some of the lawyers, so then you say, call the law society. They'll give you a list of lawyers. Well, most of those never call back, and many of them say they have a conflict in their firms because they represent big builders. That's where the money is. The money to be made is not with individual consumers. And it's even very hard to get technical expertise, engineers to testify on behalf of a consumer because that's not where the money is either. The consumer is a one-off client, whereas the warranty program and builders are repeat clients. They always pay their bills, and they have deeper pockets. So there's another imbalance in the playing field. There's also an absolutely confusing maze of legislation that consumers have to read in order to even stand up in front of the court. There's the New Home Warranties Plan Act in Ontario, the Construction Act, the Home Construction Licensing Act, the Condo Act, the Ontario Building Code, and the sales contract itself, which is usually over 40 pages for pre-construction homes, and a 12-page Ontario government-mandated addendum. It's just called the addendum. That is, I'll tell you what a Superior Court judge said about that. You don't have to take my word for it. I find it confusing every time I read it. I find it very difficult to try to explain to consumers what it means. We shouldn't be using that either. If you're asking for something you could do in an afternoon, give us a standard simplified contract in consumer-friendly language that everybody can understand before they sign it. Judge Lowers of the Ontario Superior Court said about this addendum that it was a, let's try to get his quote up there. That's okay, I skipped ahead of myself here, no worries. He said, and I quote from a case called Ingara from February 2020, "This document is a small font, single-spaced, convoluted, and confusingly long and obscure document. It is a trap for the unwary, particularly the unwary layperson." Why are we still in Ontario mandating that document as a mandatory part of every new home construction, every new home purchase contract? The purchase contracts are written by developers. This is government mandated, so government, through its two agencies, had a hand in writing it. It's appalling that even a Superior Court judge has said this 6 years ago. There was a Toronto Star article about this as well, calling for action from the Ontario government. Over 6 years has passed and nothing has been done. So I would say to this action committee on access to justice, this may be an afternoon's work for somebody to say, here's the resale new home contract, 6 pages, even I can understand it. Why not for pre-construction homes give those buyers and those consumers the same rights to be able to understand their contracts? Even judges are having trouble understanding it. A lot of lawyers hate it. We shouldn't be using it. So that's an actionable area. I wanted to also touch on what this slide touches on, some of the hurdles that self-represented litigants have in court. They lack the cross-examination skills that you spend years learning. They are emotionally involved in their cases because it involves their home and their life savings. So therefore, that anxiety adds to the confusion and the frustration that they feel. Family relationships and health can crumble under the stress. We've even very tragically had suicides take place because of the stress and the financial disaster which can happen to individuals who get themselves embroiled with a powerful builder and a powerful government monopoly who doesn't understand their issues and contracts which are out of balance. I'm talking about Ontario. I don't know what the other provinces in Ontario have, except the system is quite different in BC and Alberta. Court procedures are complex for us non-lawyers. You miss a deadline and your whole case could be destroyed. Legal jargon is confounding. Things like estoppel and res judicata and things like that, those are not household words. Even if you can look up a definition of them, you don't understand what they mean. Anyway, you can see what but what about the actionable points? Simple standard contracts. Bring back what the federal government said it was going to do several years ago, a new home buyer bill of rights or a home buyer bill of rights. Nothing has ever really been done on that. That was a blueprint. There it sits with the federal government. Nothing much has been done. That's an actionable item. And the third actionable item is legal insurance. Why don't we have in Ontario what they have in Quebec, the UK, the Netherlands, and France? With your mortgage for $12.98 per month, you can buy legal insurance to protect yourself against some of the legal disputes you may fall into in new home buying. And in closing, the soccer coach I mentioned at the beginning, he said, football is the simplest thing, but it's so difficult to be simple. And I think I've given you 3 ideas which are actionable that I'm prepared to roll up my sleeves to help accomplish them. So I'm appealing to this action group to please help the average consumer in Ontario. Thank you.
Thank you, Barbara. Okay, next we have Jessica Moy. She holds an LLB from the University of Sherbrooke and a master's in social innovation management from HEC Montreal. She's was called to the bar in 2018 and has experience in civil commercial litigation, as well as experience with Legal Aid Montreal. Since 2024, she's been the Director of Programs and Community Relations at the Quebec Bar Foundation, and is involved in a particular initiative that I think you're going to speak to this morning, involving the Superior Court's Citizen Collaborative Committee. And she's also the co-founder of the Montreal Firefighters Ecological Transition Committee. So welcome, Jessica.
Thank you so much. I am presenting in French. I don't know if people have their... It's okay?
We've got the transcripts will come up
Oh,
here.
awesome. Okay.
So if anyone wants to grab a set, but they will be on the monitors.
So thank you. Thank you so much for having me. This is a huge moment for me for many, many reasons. So I'm really happy to be here to be presenting my thesis to you today. And so I'm going to speak in French now since my presentation is in French, but it would be my pleasure to answer your questions in English later on. Donc, mon sujet de maîtrise, c'était la participation citoyenne en accès à la justice. Je vais changer la diapositive. How do we do? No.
Oh, he has to present it. It's not in present.
Est-ce que, sorry, can you change it for presentation mode? I'm not able to change the slides. Can I get another 2 minutes? Ready? Okay.
It's okay. Stop the clock.
Now I'm all confused. I'm confusing myself. Donc, aujourd'hui, je vais vous faire la présentation de ma maîtrise, de mon mémoire. Donc, je vais débuter avec une petite introduction. Ensuite, je vais vous présenter un peu la problématique que j'ai identifiée. Je vais vous faire une revue de littérature très courte. Je vais vous présenter la question de recherche ainsi que la méthodologie employée, mon cadre théorique et quelques résultats là, dans le cadre de mon mémoire. Donc, en 2005, vous connaissez probablement très bien Roderick MacDonald, qui est venu soulever justement des enjeux majeurs par rapport à l'accessibilité physique aux lieux, notamment les palais de justice, pour les personnes à mobilité réduite. Donc, en 2005... Je tiens à le souligner. En 2018, un avis Google du Palais de justice de Montréal soulève le fait qu'une femme s'est déplacée avec son père au Palais de justice et il semblait plus avoir de fauteuil roulant à la disposition des gens. Et donc, elle a eu de la difficulté à aider son père, dont elle n'avait pas la chaise roulante avec elle cette journée-là. En 2024, je me déplace au Palais de justice pour la rentrée des tribunaux. Et je n'ai pas ma carte du barreau, donc je dois passer par l'accès pour les citoyens et les citoyennes. Et je rencontre un dénommé Jim qui, visiblement, est en situation de mobilité réduite, frustré parce qu'il doit enlever sa ceinture pour passer par la sécurité avec sa canne. C'est vraiment pas évident. Donc, je lui demande, est-ce que je peux vous aider? Est-ce que vous souhaiteriez peut-être un fauteuil roulant pour vous aider? Il me dit oui, excellente idée. Je suis parfait, mission. Donc, je me déplace pour essayer de trouver un fauteuil roulant. Impossible. Donc là, je me dis, OK, je vais au poste d'accueil. On me dit, oui, on a des fauteuils roulants, mais en arrière ici. Je dis, OK, mais est-ce qu'on pourrait l'avoir pour quelqu'un? Il me dit, oui, mais il me faut une pièce d'identité. Bref, je vous épargne les détails, mais c'était extrêmement difficile. Trouver un fauteuil roulant pour quelqu'un, surtout qu'en temps normal, on pourrait s'imaginer une file au poste d'accueil que ce monsieur-là aurait dû attendre très longtemps, là, même pour parler avec l'agent en question. Donc, le contexte de la recherche, beaucoup de recherches a été effectuée au Québec, notamment par rapport à l'injustice épistémique, donc le fait qu'on ne considère pas les savoirs expérientiels des citoyens et des citoyennes dans la réflexion sur comment on pourrait améliorer notre système de justice. On a aussi de la recherche qui parle de placer le citoyen au cœur du système, qui propose même une hiérarchie des savoirs, c'est-à-dire que les savoirs des citoyens et des citoyennes devraient être placés au-delà des savoirs des experts. On a le Forum québécois sur l'accès à la justice qui a aussi cette idée-là de placer le citoyen au cœur de l'action. Et le plan stratégique du ministère de la Justice du Québec dont la vision est d'offrir une justice centrée sur les besoins des personnes. Donc, ce n'est pas un nouveau concept. Et à la droite, on a certaines initiatives. Il y en a une ici, mais il y en a quand même eu plusieurs là, au cours des dernières années, dont l'IQRDJ qui a fait un forum citoyen en 2020 pour aller recueillir justement les opinions des citoyens et des citoyennes sur comment on peut améliorer le système. Dernièrement, quand je vous dis vraiment dernièrement, c'est littéralement dans les 3 derniers mois, le Barreau du Québec a fait une tournée pour aller chercher le pouls des citoyens et des citoyennes par le biais d'un panel qu'ils ont pu partager leur expérience avec la justice. Donc, et aussi, si vous allez à la conférence cet après-midi, la Cour supérieure a aussi mis en place un comité collaboratif citoyen. Donc, la problématique, l'enjeu d'accès à la justice, on le sait, non seulement est grave, mais prend de l'ampleur. Et malgré les solutions existantes, en fait, ça ne fait qu'augmenter. Donc, on a constaté que peut-être les solutions qui sont en place sont peut-être méconnues ou qui ne sont peut-être pas adaptées aux besoins des citoyens et des citoyennes. Et l'hypothèse que j'avais, c'est que les personnes citoyennes ne participent pas à la construction aux solutions visant à améliorer l'accès à la justice. Qu'est-ce que je veux dire? C'est que si vous allez créer un projet, un OBNL veut créer un projet en matière d'accès à la justice, est-ce qu'ils le font chez eux, à l'interne, ou est-ce qu'il y a une consultation faite à l'externe avec les citoyens et les citoyennes pour identifier c'est quoi le besoin qu'on veut régler ici, c'est quoi la solution qu'on pourrait mettre en place, comment qu'on pourrait présenter cette solution-là et surtout aussi comment qu'on pourrait l'améliorer. Donc, ma maîtrise est en innovation sociale, mais j'ai un parcours en droit, donc j'ai voulu concilier ces deux mondes. Et donc, la revue de littérature par rapport à l'accès à la justice, on peut concevoir l'accès à la justice comme étant une finalité, vous la connaissez quand même assez bien, mais on a cette transition-là vers l'accès à la justice comme étant un processus. Donc, la justice centrée sur les besoins, la justice participative, etc. Et un peu comme qu'on disait hier, cette idée-là que la justice, c'est une responsabilité partagée de common good, on se positionne plus à droite. En innovation sociale, ce que j'aimerais que vous reteniez, c'est qu'une innovation sociale, c'est, oui, certes, une nouvelle idée, mais l'étoile, par faute de temps, là, c'est vraiment que c'est une innovation qui est initiée par les acteurs eux-mêmes. Donc, pour la méthodologie de la recherche, j'ai fait 12 entretiens avec des gestionnaires d'OBNL ou d'institutions situés à Montréal et dont la mission était d'améliorer l'accès à la justice au Québec pour les citoyens et les citoyennes. Pour le cadre théorique, si vous connaissez un peu la participation citoyenne, vous voyez souvent le cadre à la gauche qui est les échelles de participation citoyenne. Mais quand j'ai voulu coder les données, c'était très, très difficile de les coder avec le cadre de la participation citoyenne. Donc, j'ai opté plutôt pour un cadre théorique qui était relativement nouveau à l'époque, qui est la boussole de la justice épistémique, qui est utilisée en innovation sociale. Donc, l'idée, c'est vraiment, vous allez voir les cases, celles avec les étoiles, c'est les cases que j'ai utilisées pour analyser les données. Donc, à qui ça profite, qui parle, qui est entendu et qui fait. C'est un outil qui pourrait être utilisé au début du projet pour mieux s'enligner de comment qu'on va aller de l'avant avec la création d'un programme. Donc, à qui ça profite? Je vous présente un peu les résultats. Premièrement, j'ai divisé à qui ça profite en 2 sous-catégories. Qui est visé, qui est impacté. Qui est visé? Donc, quand j'ai posé la question sur qui est visé par vos programmes, on a vraiment une diversité des populations qui ont été visées. Oui, par la localisation géographique, aussi par l'appartenance à un groupe social. On vise les jeunes, on vise les aînés, on vise les immigrants, mais aussi par leurs conditions sociales. Les personnes appauvries, les personnes pauvres, les personnes vulnérables. Ensuite, on a constaté qu'il y a une absence quand même de données détaillées sur les profils sociodémographiques. On va aller chercher le genre, peut-être l'occupation, mais on n'a pas plus de détails à l'interne là, par rapport au profil. On voit aussi une certaine généralisation des besoins, c'est-à-dire on est conscient qu'il y a certaines différences entre les populations anglophones et francophones, mais on peut quand même se dire que c'est sensiblement la même chose. Donc, une généralisation des besoins des francophones aux anglophones. Et si vous le savez, c'est surtout au Québec, hein, pour les anglophones, c'est quand même très difficile. Et dans les autres provinces aussi, pour les francophones, l'accès à la justice, c'est un défi. On le voit aussi au niveau de la généralisation d'un groupe. Donc, les aînés, tous les aînés. Hein, tous les aînés ont les mêmes problématiques. Tous les immigrants ont les mêmes problématiques. Et le dernier point, pour moi, qui est quand même très important, si vous reteniez une chose aujourd'hui, j'aimerais vraiment ça que ce soit ce point-ci, c'est qu'on utilise souvent le mot vulnérable. Les personnes vulnérables. Tout le monde est vulnérable. Hein? Donc, on a d'un côté les termes vulnérables et on n'utilise pas en situation de vulnérabilité. On utilise personnes vulnérables. Tandis que de l'autre côté, on parle de empowerment. On veut autonomiser ces gens-là. Pour moi, il y a quand même une certaine contradiction dans la mesure où le terme vulnérable a une connotation très négative. Donc, on a déjà une certaine perception. C'est pas nécessairement l'intention. Je dis vraiment pas que c'est ça, mais c'est une utilisation courante qui porte un certain poids. Et si ces gens-là savent qu'on les appelle vulnérables, je me demande c'est quoi vraiment leur perception vis-à-vis leur capacité d'être empowered, hein, d'être dans cette posture d'autonomisation. Donc, qui est impacté? On a constaté qu'il y a une différence entre les personnes qui sont visées et les personnes impactées. Donc, les personnes visées au grand public. En fait, quand on vise le grand public, on vise personne, mais grand public. Tandis que les personnes impactées, ça pourrait être justement un outil pour le grand public, mais finalement, on se rend compte que c'est peut-être un outil plus pour les étudiants en droit, c'est peut-être un outil plus pour les avocats. Donc, on n'atteint pas nécessairement la cible qu'on a visée au début du projet. Un défi qu'on a en accès à la justice au Québec, c'est que les évaluations d'impact sont peu fréquentes parce que ça coûte cher et les OBNL ont peu de ressources financières, matérielles, etc. Donc, c'est quand même assez difficile de dire, bon, on a mis en place un projet, mais c'est quoi les véritables impacts de ce projet-là? C'est un peu ambigu. Donc, qui parle, qui est entendu et qui fait? En analysant les données, j'ai pu créer, vous allez voir, là, vraiment plusieurs groupes de personnes. Donc, les personnes bénéficiaires passées des services de l'organisation, les personnes bénéficiaires potentielles des services, les personnes qui ont refusé ou qui ont été refusées un service, les personnes qui ont un vécu expérientiel, les membres de l'organisation, le grand public, ainsi que les organismes en justice, les personnes intervenantes, on peut penser les médecins, et les bénévoles à titre de porte-parole des citoyens et des citoyennes. Donc, dans un projet d'innovation sociale, on a plusieurs étapes. La première étape, c'est l'étape de l'émergence. C'est quand on veut réfléchir à la solution qu'on veut mettre en place, essentiellement, et qu'on se regroupe pour créer la solution. Donc, au stade de l'émergence, ce que j'ai fait, c'est que j'ai pris un exemple, parce j'ai pas beaucoup de temps, mais par rapport à la catégorie des personnes bénéficiaires passées. Alors, au stade de l'émergence, dites-vous que c'est au début du projet, essentiellement, les personnes citoyennes ont été sollicitées pour comprendre un peu leur savoir expérientiel de leur expérience dans le processus judiciaire, et c'était pour valider une hypothèse que l'organisation avait déjà en tête. Mais ce qui est arrivé, c'est qu'au final, c'est vraiment une très belle réussite de la part de cette organisation-là, c'est que la participation a mené à un changement au niveau du programme qui était initialement envisagé. Il y a un deuxième volet qui a été ajouté pour mieux répondre aux besoins qui avaient été identifiés au stade de l'émergence. Donc, bravo à cette organisation-là. Au stade de l'expérimentation, la solution existe et on veut la tester auprès du public cible. Donc, ici, c'est les personnes qui ont refusé un service ou ayant été refusé un service. Donc, parfois, ces gens-là sont consultés dans l'évaluation du projet, mais plus souvent que pas, ils ne le sont pas. Parce qu'on a peur des opinions négatives. Hein? On ne veut pas les inclure. On se dit, ouais, mais finalement, ils ont été refusés un service, ils vont avoir rien de bon à dire. Mais c'est faux. Parce que l'opinion des personnes qui ont été refusées un service ont probablement des éléments très importants à ajouter qui pourraient certainement bonifier un programme. Donc, ce que je voulais vous dire aussi, c'est que ce refus-là, il ne faut pas nécessairement se dire que le refus est explicite. Je ne veux pas votre service. Des fois, on peut l'interpréter par le silence. Hey, j'ai mis en place un programme, j'ai personne qui se présente. On peut se poser des questions. Donc, parfois, ce refus implicite a servi pour se dire « Ah, mais peut-être le moment n'est pas opportun pour ce projet-là. ou est-ce que peut-être on pourrait le modifier? Est-ce qu'on devrait y mettre fin? Donc le silence ou le refus a quand même une très grande valeur. Au stade de l'appropriation, c'est qu'on a testé notre solution et maintenant les citoyens et les citoyennes vont se l'approprier, vont l'utiliser. Donc, les bénéficiaires passés, c'est quand même assez classique. Vous le savez, c'est qu'on a reçu un service, on vous envoie un sondage de satisfaction pour recueillir un peu votre opinion par rapport au service rendu. Les commentaires en général pour ce genre d'initiative-là ont été jugés vraiment comme servant uniquement, majoritairement, devrais-je dire, pour bonifier les dépliants philanthropiques, pour faire nos redditions de comptes aux bailleurs de fonds. Donc, c'était vraiment plus pour les partenaires. Parfois, on a jugé que les commentaires étaient peut-être non pertinents ou ayant pas nécessairement une signification importante. Donc, en conclusion, ce que je voulais vous dire, c'est qu'il existe quand même des pratiques participantes. Donc, mon hypothèse était fausse au final, donc c'est une bonne chose. Mais il y a quand même cette hiérarchisation des savoirs, c'est-à-dire que les citoyens et les citoyennes, leurs savoirs sont jugés peut-être moins importants que les savoirs des experts et les savoirs du milieu académique. On a constaté une absence de données socio-démographiques. Vous le savez, les données, c'est un enjeu majeur en justice, notamment au Québec, mais je suis certaine que c'est partagé dans les autres provinces. Les citoyens et les citoyennes, ça aussi, le deuxième point que j'aimerais que vous reteniez, c'est que les citoyens et les citoyennes ont l'occasion quand même de parler, sont parfois entendus, mais fort rarement. Et ce que j'aime de ce que j'ai entendu de mes collègues, c'est de dire, ben en fait, Meg, par exemple, self-reps lack intelligence. C'est faux, c'est faux. Et c'est dire que c'est les self-reps, que ce soit les self-reps, que ce soit les personnes qui ont été représentées par un avocat, peu importe, ont énormément de savoir, et pas juste pour partager leur savoir expérientiel, mais peuvent être autour de la table et peuvent contribuer aux discussions sur les solutions et même co-créer ces solutions-là avec nous. Donc, c'est ce que je voudrais vous déposer. Et aussi, ce que j'ai vraiment trouvé intéressant aussi, Barbara, c'était l'idée de dire, Barbara, elle est une self-rep et elle aide les autres dans leur dossier. Donc, les gens peuvent servir comme bénévoles, par exemple, peuvent aider les autres. Donc, on peut nécessairement les inclure là, à toutes les étapes. Donc, voilà. Bon, je pense que c'est terminé, mais j'ai une panoplie de recommandations. Si ça vous intéresse, ça va me faire un grand plaisir. Merci à vous.
Okay. Our final speaker is Caitlin Blazer. She's a doctoral candidate at UBC Law and a fellow with the Access to Justice Center for Excellence. Her research engages the question of what an equitable approach to access to justice looks like in the context of social and institutional realities that often create wide disparities in bargaining power, as we've heard this morning, between the parties of a legal dispute. Beyond her doctoral research, Caitlin is a part-time practicing lawyer in British Columbia, focusing on civil litigation, everyday legal problems, and innovative approaches to service. She supports Access Pro Bono and Everyone's Legal Clinic. So,
Okay, hi everyone. I'll aim to keep this as brief as possible, just so we have hopefully a little bit of time for discussion and questions. Really, I'd like just to highlight a few key points that I think emerged through these presentations. Specifically, how do we actually improve our ability to listen and understand these experiences that we are not getting enough of in discussions about reform in the legal system? So, paving the way for people-centered change is sort of the way I frame that in this presentation. And what I'll cover in this is just the context, a bit of a kind of theoretical context for why this is so necessary and so important and the scale of what we need to do. So looking at person-centered justice, I won't go into that in detail because you're all kind of familiar with the concept. But this idea of social closure, which starts to explain some of these really key epistemic divides that we see between folks like lawyers and self-represented litigants, and how that operates within an expert system, which the justice system really is. Implications for researchers, institutions, service providers. I'll really focus my comments on kind of the research context, but I think the key principles cut across different areas. Really quickly, we'll go over some participatory strategies. There's tons of literature on this in multiple different areas, so I won't dive in too deep on that. Key barriers to implementation, try to focus on that a bit, and then some strategies, areas to really consider for how do we embed deeper, better participatory frameworks. So the context here, this is kind of like the theoretical way that I kind of piece it together, some different types of theories that I work with. A key one is social closure. This comes from sociology, and it's a process for drawing boundaries, constructing identities, and building communities to monopolize scarce resources. So this happens in lots of different ways in any system, but in the legal system specifically, sort of lawyers and those types of experts are the key drivers of social closure. And you see that through social practices, institutional practices, how that feeds into rules, institutions, all of these things. And I contend that that is an extremely powerful driver of these dynamics that you see on the other part of the slide that are driving legal development, access to justice outcomes, and so on. So you have social closure, kind of the engine of all of this, creates this experience of epistemic exclusion that self-reps consistently talk about, and there is some literature on that as well. Resource availability and distribution. So social closure experts, they define how resources get used and distributed, and then that feeds into what becomes institutional and legal practices and frameworks. So the rules we create, all these types of things. And it becomes incredibly normalized. So it's kind of hard to see exactly how this is operating a lot of the time unless we're asking the right questions. And these all reinforce themselves in what is a dynamic system of law. So that is the context there. Some really important things to take away from this for kind of all of us. It becomes self-perpetuating. So if the dominant social closure system, that's what drives most of what is happening. If you operate in a legal context, you're at risk of reinforcing that if you don't proactively try to counter it. And it blocks institutional transformation. So the implications for access to justice, I think, are pretty obvious from that. So now I'll try to turn to, okay, what will it take to kind of break down this dynamic, kind of guide it in a different way? So participatory strategies. There is a whole bunch of literature out there on that, and Jessica spoke to kind of different elements of this, slightly different way of looking at it. But there are many different choices at many different touch points where researchers, designers, reformers can look at this. So there's a range. And what participatory option makes sense is going to be context specific, but I do think we need to push towards things like co-creation, co-design, and rebalancing strategies. So decolonizing approaches are one example of an established way of trying to do that, where you're trying to counter this kind of dominant dynamic. So you have to do that consciously, and you have to do that as early as possible in whatever process you're undertaking. So this can go into research, policy, service design, et cetera. Looks different across all those things, but underlying principles are really similar. But there are some really significant barriers to implementation for this. So I'll specifically kind of talk about the research context, but ideas similar in those other contexts as well. So as a researcher, if you're researching a legal context, there's kind of uncertainty and risk in doing that if you're trying to involve, litigants, users, other folks with that type of experience. So privacy identification, privilege risks. We have a kind of case-by-case test for privilege for kind of getting confidential research information potentially disclosed in court cases. So that is, there's some literature on it, how it's kind of a chilling effect. And for me personally, in designing my research, my dissertation, there is data I didn't try to collect because I didn't feel that comfortable kind of navigating those risks of what could come up, what would be disclosed to me, all of these types of things. So that alone reduced the kind of participatory benefit of my research design. And I'd love to improve the ability to get kind of true, accurate, really deep data from those who are personally experienced by the justice system. Capacity, institutional expectations, lack of shared practices. So participatory research, we see it in some access to justice work. There are definitely organizations, researchers who do it, but it's not necessarily the norm. And in legal context more generally, it's definitely not the norm. In law schools, it's not the norm, all these types of things. And capacity, if you're doing participatory research, requires more coordination, more relationships, more time very often than other types of kind of more traditional legal research. And academics, researchers, they're not known for having, extra time, extra resources, extra capacity. So that's a conversation that needs to happen as well. And then trust, trauma, epistemic divides. That's obviously quite a huge topic that I can't really go into far enough for this. But the nature of your relationship with like a participatory person in your research, the value and type of information that you get is going to be impacted by any mistrust, any trauma, all of these. So trauma-informed approaches, building a relationship, working with partners who already have pre-existing relationships, all of these things can improve the kind of quality of the data we get when that quality is kind of impacted by these very real dynamics. And lastly, strategies. There's much more to say about all this, and all these kind of require deeper discussion. But as I mentioned, prioritizing co-design and co-creation. So this is kind of a more equitable version of participatory work. So instead of, consultation, getting views from a survey, that type of thing, you involve folks earlier on and you do things collaboratively. From the research perspective, you can design research questions with participants. Build shared practices and best practices for legal context. So an infrastructure for doing this type of work. Networks, mentorship, guidance documents. So, research partnership agreement guidance, templates, those types of things that researchers can share amongst themselves, organizations that can very specifically talk about these strategies. This kind of exists in other academic contexts, but we don't see it much in law. Even getting mentorship for how to do this work is that I've found personally to be pretty difficult. So I've kind of made it up as I've gone along, asked a few folks, tried to cobble something together. And then, larger scale data collection, like we talked about in the first panel, that really complements being able to pinpoint how and where to do participatory research. So that needs to increase as well. And kind of institutionally incentivizing this work through kind of like grant funding, how we kind of evaluate productivity for researchers and service and all those types of things. So kind of gearing it towards this is something that we deem important. And then there's different options for kind of policy and legislative reform. So in the research context, there's more we could do around reducing the uncertainty around risks of disclosure of confidential research data. And there's some papers on that I could chat with anyone about if they'd like. And the most important part, I think, and this is what I'll end with, is building lasting and long-term participatory relationships and institutional structures. So if you remember social closure, that is based on long-standing repeat interactions of experts kind of creating a system and a dynamic. We can't counter that with kind of one-off interactions, one-off studies, that type of thing. So we need these relational, very deep, kind of building that out as much as we can to try to kind of counter those very strong dynamics that exist right now. So I will leave it at that. Hopefully we'll have time for a few questions.
Thank you, Caitlin. So we have two questions that we are to sort of tackle as part of the conference organization, but I wanted to see if there were any questions from the audience before I pose those to the panelists. Oh, okay. So the first question is, we could spend the rest of the day on this one, but what reforms have we, as a panel, or you as a panel, identified that would improve access to justice? Now that is a massive question, but maybe just a thought from each of you in that regard. So Meg, I'll start with you. What reforms?
Yeah, sure. I spoke mostly to feedback from self-represented litigants, and I think Jessica certainly and Barbara also underlined that. I think maybe the interplay is about kind of how, like what that methodology is, whether that's a formal evaluation methodology, whether it's more of an ethnographic approach, an open-ended kind of versus close-ended. We could debate that. I also just thinking about Catherine's, presentation just now, it made me think about the importance of like the governance of the legal profession. So how to sort of work that feedback into the way in which lawyers themselves, and hopefully judges, although that's a bit of a different can of worms, but how those, how the reward systems work within the legal professions as well.
Barbara?
Well, I'll just reiterate that I don't think self-represented litigants should be in court against 2 or 3 or even 1 experienced lawyer because it's not a level playing field. And I think we need legal insurance. We need something to fix that. If we keep on doing this, the number of self-represented litigants in Ontario is growing, I think. And it's not fair or balanced to administer justice that way. And it just makes people angry at the justice system. It makes people angry in society. It devastates people emotionally and financially. I just think we shouldn't be doing it.
Okay. Just to keep the Justice Lauer's theme running through all of this, one of his sort of quotes in a case was, to send a self-rep into court with a represented party is like sending a boxer into a ring with one arm tied behind their back. Yeah.
I agree.
Jessica.
Oh, so much to say. I think I'll go with participatory practices. We need to have more of an open door policy. I think we tend to discuss amongst ourselves a lot, which is great because we can share practices. But I do think that if we open the doors, I understand there's a bunch of constraints around that. It'll be too long. It's going to be complicated. They won't understand us, etc. But I do think there's a way of designing, notably, this type of initiative and including citizens in the process. So I think to always keep in mind of that possibility, and instead of saying all the reasons why it can't work, I think we need to start focusing on the reasons why it could work, and that's what I would say.
And potentially recognize the benefits of that open door in terms of a dialogue. It went off?
It's back on. Yes, exactly. I do think there is a shift. However, I do have to say, in Quebec, there is an understanding of the importance of citizen participation, so I can't say that there is not. I think that the issue is really just the fact that they don't have the time to do it, or they don't have the resources to do it. And I think that's maybe the other reform that I would propose, is this idea that when we apply for grants for projects, that it becomes a criteria in when we're building the project. However, the money needs to be there and the expectations need to be adjusted because it does take longer and it does require more money. So yeah.
Okay, perfect. Thank you. Caitlin.
Yeah, I think I'll keep it at kind of like a high policy level. Like obviously the participatory stuff, improving that across all domains, like I mentioned, really important. But also, it's just, we need much more public investment into making sure that more folks can get legal services. And I don't necessarily mean a lawyer. I mean, multidisciplinary legal practices with different scopes for different levels of complexity. So the kind of obvious answer, but the one that remains true, and we saw with the statistics earlier this morning, like those costs still exist. They're just being externalized through kind of much more expensive and harmful costs in society. So the numbers, it just makes sense. But we also need to think about, okay, like this expert system, how can we kind of start to dismantle that a little bit? And lawyers need to have a lot of self-reflection about their kind of role in where we are today.
So open door and maybe multi-door.
Yeah, absolutely.
The second question is, what unanswered questions should access to justice academics and researchers take back for further study? So if there was an area, we sort of know what the reform we would like to see what reform looks like, but how do we get there, I guess, would be maybe the question.
So I wanted to say that I disagree with Barbara on whether self-reps should be in the courtroom against teams of lawyers. After having had the experience of articulating my own interests in court and seeing how that can hit at a different level, and in the interplay and what I've observed to be different models of justice that can be pursued in the courtroom, including from people from different cultures, as well as decolonized approaches to justice. I don't think we should force people to shoehorn themselves into this kind of very strict and outdated, in many instances, formulation of justice by the legal professions. I think actually that would be a step backwards at this time. So that maybe isn't my unanswered question.
Okay. Barbara.
I think if someone insists on self-representing, they should certainly do it, but often the expectations are that people are going there to get justice, and what comes out of the court is often a disillusionment and anger with the system, and I think we can avoid that. Plus, the taxpayer funds the court system, so I think taxpayer funds are scarce, at least in Ontario, and the court systems are overburdened, so there has to be a better way to level the playing field, and I think most consumers go in thinking they are prepared and they are skilled. I was one of them. And being right and proving you're right in court are two different things.
Yeah, and I mean, I think the thing to think about too is that for most people, going to court on their own is not a choice. They are compelled to do so for lack of funds, basically. I mean, that's the biggest number we see. But to the point about when they get there, how prepared they might be versus what they're kind of thrown into, to sort of harken back to Paul Aderman this morning and our kind of obsession with the adversarial system, there could be other ways in which we resolve many of those disputes that aren't so traditionally adversarial, and you would not also need to have legal representation. So I think that's always got to be in play.
Okay, but I have to say that lawyers typically in Canada and in the United States, they say that they're interested in alternative dispute resolution, but when it comes to their practice, they want to offer the strongest case that they can to their clients, and that's typically going to be the adversarial case because of the bulk of history and contemporary practice and the uncertainty of what the other side is going to want to do. So when you ask lawyers, well, have you used any of these alternative dispute resolution mechanisms? Because they do exist. Like, there are lots of options. They haven't tried them, and they don't typically do them.
I'm not talking, though, necessarily about alternative dispute resolution. I'm talking about a difference in process within a dispute resolution process. So, we're going to have to have a system where people sort out their differences, and it's not always going to be alternative. There could be another way of doing it, sort of outside the adversarial, that is, say, more inquisitorial in certain contexts. And certainly that's an argument that's often made in family law, for instance. But that's different, and I agree with you. I agree, but the lawyers in this country operate within an adversarial system. That's it. That's what we have. And the alternative is a tack on to that. But it's not really, truly an alternative. The system is adversarial. So I agree with you. I just think that it's the adversarial piece that might need to change. But we're getting a bit side. I want to get to Jessica and Caitlin just before we wrap up.
Yeah, I think one of the unanswered questions, the very uncomfortable questions, but is to do a little bit of introspection in, like, what are we holding on to? Like, why are we holding on to this desire to be the experts? Where does it come from? And why are we so, I have an idea, because in law school we're told that we're, the brightest and the best, and you're so lucky to be here. And, that's dangerous because it contributes sort of to that hierarchy that we then transpose into our practice and the way that we interact with people. And I think if we go in with the premise that we're all equal, regardless of what we do, I think that I have knowledge and you have knowledge and everybody has knowledge and everyone can bring forth their knowledge on an equal playing field. So it's a very uncomfortable question. I know it's maybe not popular. It's a big one, but it's an important one.
Yeah, and I definitely agree with Jessica's point there. I think that's very important. As far as unanswered questions, something I would like to see as far as, we'll just talk about data. So we have unmet legal needs data, which is, it does open a lot of doors for what to think about. But what we don't really have is like the flip side of that. We don't have very good data on, okay, what clients, what interests, what needs are lawyers actually servicing? Like how does that market break down as far as, how many lawyers are representing individuals in these types of cases, how many lawyers are representing corporations, institutions, governments? What does that breakdown look like, and how does that match up with this kind of unmet legal need that individuals experience? So getting at the structure of the legal market, understanding the dynamics of it much better, can kind of show us where lawyers are essentially kind of failing the population. So I would love to see way better data on that. Practice data from law societies is basically, from my perspective, a mess, and it doesn't allow you to directly answer those questions without doing an incredible amount of legwork. And even then, the answers are not very clear, and they're not, you can't be totally certain that you're coming to the right conclusion. So that's data I'd personally like to see.
Okay, thank you. Well, we're 2 minutes over time, so I will stop there. But thank you so much, all of you, for presenting this morning or today. Thank you.